A Section 25 notice does more than set a date. Miss the termination deadline and you could lose your right to renew the lease, leaving your business in occupation without authority. Once that notice expires, the landlord is no longer bound to offer renewal terms that match the old lease. Act early and you keep leverage to negotiate the rent, the term, and a workable exit option. If the landlord is not opposing renewal, the notice must set out the proposed new lease, including the property, rent, and the other terms they want. If renewal is opposed, the notice must say so plainly and identify the statutory ground the landlord relies on. The Section 25 notice must be served in a tight window, no more than 12 months and no less than 6 months before the termination date. And that termination date cannot come before the lease's contractual end date. Put simply, your notice cannot bring the lease to an end early. The common opposition grounds are disrepair, rent arrears, other lease breaches, suitable alternative accommodation, redevelopment, and the landlord's own occupation. 2 grounds need special attention. Redevelopment, ground F, and owner occupation, ground G, can lead to compensation if they force you to leave the premises. The tenant can take the initiative too. A Section 26 request starts the renewal process and can give the landlord up to 12 months' notice. When both sides want a new lease, the fight is no longer about whether you stay, it is about the rent, the term, repair obligations, and the other commercial terms that will shape the next lease. In Caterpillar Property v Parkcakes, the Court of Appeal held that an unexercised contractual renewal option did not remove the tenant's Part 2 protection. The court treated the option as closer to an irrevocable offer than an agreement for a future tenancy, so the option and statutory renewal rights can run in parallel. That urgency is not theoretical. Sunnymead showed how a last-minute filing can spark a dispute over whether the proceedings were actually issued in time. For redevelopment opposition, a landlord needs more than an aspiration. The intention must be firm, settled, and viable, backed by plans, consents, funding, a timetable, and evidence that a contractor can deliver it. If the landlord proves a statutory ground of opposition, the court can refuse renewal and possession can follow. If the ground is not proved, the court can order a new tenancy on statutory terms. And where you are displaced on a no-fault ground, compensation is generally 1 times rateable value after under 14 years of occupation, or 2 times rateable value after 14 years or more. A Section 25 notice can set the clock running, but it does not have to decide the future of your premises. Speak to Dominic Levent Solicitors for a confidential review of your notice and your renewal rights. Act before the deadline, and we can help you plan the next move with clarity.